Donna's right. I was an assistant DA for a year, just in the misdemeanor section. After a year, I was made the misdemeanor section chief and oversaw the section for about a year. And at that time, I felt it was, it's always been a lifelong dream of mine to go into private practice for myself, so I left and went into business for myself. So the presentation, you'll have to forgive me, it doesn't have a DA logo. You can barely see it, but it's got my firm logo, so you'll have to forgive the indulgence to have the firm logo on there. But I'm flattered, honored. Don asked me to come back, even though I'm not the DA's office anymore, to speak about DWI and 894. So I will speak about it from a standpoint of what I remember as being a prosecutor, as being a DA, what we did as prosecutors, how it worked. Also, I've seen some things now on the defense side because I've done expungements for folks. So I've seen how the expungements work, specifically in the context of 894, and what you see from defendants, especially in the context of driver's licenses, the practicality of it when you actually get a DWI, if you're put on pretrial, if you're put into 894. Also, Donna sent me a listing of some questions that some of you had provided. One of them was about an issue related to somebody got arrested for DWI. Who asked that question? Got arrested for DWI, I think in Lafayette, went on to East Baton Rouge Parish, got into another accident, asking if the legislature was doing anything about that. Is that person here right now? No? Yeah, in the back? Oh, okay, yeah. Okay, Denham Springs, okay. I got your question, and I will address the legislative updates, and I'm going to go through, and what I did is I went through the 2016 bills that have been filed in the legislature related to probation. So I want to talk a little bit about the legislature, what they're doing, talk about DWIs, talk about 894s. It's not going to take me that long, I don't think, probably 20, 30 minutes, and I'm going to open it up for questions. The rest will be you guys, okay? And throw them at me, and we'll see if I can dodge them or handle them or how it goes. So, first thing I want to talk about, just in general, DWI generally. God, that's small. I'm sorry, guys. Can you hear me in the back? I'll just have to shout that because that's incredibly small. So what you already all know, this is simple stuff. What you already know, DWI generally. I'm only going to focus on the first offense because that's the one most likely to be eligible for an 894. You all know this, your penalty $300 to $1,000 and or 10 days to 6 months in the parish jail. Again, increased for a first offense to the point to where your minimum is 10 days in the parish jail. That's a change. Now that 10 days, as you know, can be suspended, and it can be suspended provided that 48 hours of the time is spent in jail. So again, all they do is reduce 10 days down to 2 days in jail. So you still got to spend 48 hours in jail, or this is what happens most of the time, or in lieu of the 48 hours, you've got to do 32 hours of community service, half of which has to be in litter abatement. Of course, you've got the driver improvement program, you've got any kind of substance abuse program. Cannot operate a vehicle, this is what's interesting, cannot operate a vehicle without an ignition interlock device. We'll get into that further as we talk later. So you have your DWI penalties generally. Okay, 894 generally, and I'm going to talk about 894 in the context of a DWI. In general, the rule for an 894 is this. You are eligible for one every 5 years. You can get an 894 once every 5 years. This is a common misconception that I want to talk about. People misuse these terms constantly. The sentence was suspended or the sentence was deferred. What does that mean? People chronically refer to 893, 894, 895 in the exact same way. They say the sentence was suspended. That's simply not true. If you're placed on probation under like an 895, a traditional probation, that is the truest example of a sentence that, for instance, 6 months suspended, placed upon 1 year supervised probation. You have a finite set amount of time that has been suspended. 894, what makes it so different and what makes its effect so different, it's a true deferral of the sentence. The court does not actually sentence the person. It defers imposition of sentence and places them upon probation, which you guys all know. But the practicality of that is it actually gives you as probation officers a little bit bigger of a hammer to use. Because if, for instance, the sentence suspended is 2 months or 3 months, well, that probationee knows what they're facing. 2 months. If you go under 894, the probationee has no clue. And it very much depends upon the judge, right? So if the probationee is under 894 and they do not complete the terms of their probation, they don't show up, they don't know what they're supposed to do, you can honestly tell them you could possibly face the maximum. Because your sentence was never actually imposed and then suspended. Your sentence was truly just deferred until a later date. Does everybody understand the difference between deferral and suspension? Or am I giving you stuff you already know? Yes, ma'am.
Well, our judges, what they'll do is they'll sentence them to an evaluation so that the sentence is deferred until after they have a substance abuse evaluation. And then they go back before the judge to get their sentence.
Really? So then when he sentences them, if their evaluation is, say, good for them, all right, let's just assume their evaluation is good, and they be eligible for an 894, does he then sentence to an 894, or does he?
Yes.
He does?
Yes.
Okay. Even at that moment, I don't know what words he's using from the bench, but even in that moment when he sentences them, he may be delaying his determination of an 894, which is fine. But even in that moment when he decides after the substance abuse evaluation to give an 894, he has not suspended a sentence on that 894.
They're not suspending the sentence.
Okay, they're not? Okay.
Deferring
Right,
the
deferring it. Good. Yeah, good. So he delays it, he waits for his evaluation, and he again defers the sentence instead of suspending or imposing a sentence and suspending it. The biggest difference with a deferred sentence is you've never actually been sentenced, which applies to expungements. If you don't have a sentence, if you don't have a conviction, we'll talk about that, what that does to an expungement, but it is a deferred sentence. Now, DWI in the context of an 894. 894s in general, like I said, are 5 years. You may know this. 894 DWI, big giant exception, 10 years. 10 years. You can only have one 894 every 10 years on a DWI. Now that applies also, which we'll get into this in a little bit, the whole cleansing period issue and how exactly that works. But only one 894 in 10 years for DWI. And also when you go back to the court to try to get your 894, there's a special condition in regards to that you've got to provide, as the Code of Criminal Procedure provides. There's a certain letter and certifications that DPS, Department of Public Safety, as well as the Department of Motor Vehicles provides. The court mandates, or the legislature mandates by law, they have to keep certain records, fingerprints, the original plea, I think also birth date, social security numbers, etc. All that's got to be kept by those departments. And when you go to try to get your 894, at that point in time, you've got to go obtain those records from those departments to get your 894. Very different from any other kind of 894 that you would walk in and obtain your expungement, so to speak. It's a very different situation for DWI. Okay, the cleansing period, 10-year cleansing period. This applies both to expungements and to enhancement. There is a lot of confusion, even among my fellow former prosecutors and even defense attorneys. Defense attorneys, even though I guess you call them my peers now because I'm on the dark side, but even my peers don't understand this. They think it's a simple 10 years. That's not true. If you get a DWI in 2005, they love to say, well, it's 2016, game over. It's a new first offense. That's not true. We had a prosecutor in our office who recently retired, Lester Robertson, been there forever. And one of his famous cases was he was a felony prosecutor. He expanded the 10-year period to 27 years. Now, how did he expand it to 27 years? It's amazing what the statutes provide. It's one word, and all surrounded around one word, clean. It has to be 10 clean years. And clean is defined as any time that you're not being watched, supervised, or on any kind of condition to any court. You're not held responsible to any court of law. So you're convicted for, let's say, simplicity's purposes, you're convicted April 1st of 2015. You're placed upon 1 year of probation, and you check in. Let's just assume they would do this. It never happens this way. They check in amazingly studiously at April 1st of 2015, and they begin their probation. Their 10-year cleansing period does not begin until April 1st of 2016. At that point, they can have 10, if they have it, 10 clean years. And at the conclusion of that 10-year clean period, then it no longer can be used for enhancement purposes. But here's the difference. That's in terms of enhancement. Let's talk about expungement. Because the sentence that I'm talking about, person is found guilty, pleas under 894, and they plea April 1st of 2015. Because they did that under 894, and the sentence was deferred, remember, not suspended, but deferred. Because the sentence was deferred, at that very moment, the very moment they finish probation, they are eligible for their expungement. That's what 894 does. That's the beauty of 894. That's why defendants seek it. It gives them the immediacy, which I think is my next slide. No, okay, I'll get to it. The main difference is the immediacy of the effect. For example, expungements in general, again, it mirrors 894, only one per 5 years. Any misdemeanor, with the exception of registration of sex offenses and domestic abuse battery. But this is what's interesting. Any misdemeanor, aside from the two I just mentioned, is eligible for expungement, regardless of 894. Regardless of 894. Any misdemeanor is eligible for expungements, provided have to remain clean for the 5-year period, right? Remember, have to remain clean for the 5-year period, or in the context of DWI, for 10 years. So let's assume you have a DWI that's not under 894. That person would have to wait through their cleansing period, because that DWI first or second offense is still a misdemeanor, so it still, of course, can be expunged. But if for whatever reason it's not under 894, they're going to have to wait and show that cleansing period, right? Now, if they get the 894, the benefit they have is the immediacy, because it was deferred. As soon as probation is complete, they move for their expungement. In practical purposes, really the effect that you have as probation officers, the amount of control and authority you have over them as probation officers remains the same. You have all of the conditions available to you of 895. The only difference is you have a little bit different of a hammer, in that you can say, if you screw up, you can face the maximum. As opposed to 895, they know what they're facing. That's the biggest difference. And again, this is what I was saying earlier that I would get to. Main difference, the immediacy of the effect. The immediacy of the effect. When exactly it can occur. That's the broad overview of 894 DWI, okay, as it sits kind of from a 64,000 standpoint, 64,000 foot standpoint. I want to let you throw the questions at me that are very specific, and we'll deal with those one at a time, case by case. But I want to lay the basic groundwork for that. And then I want to talk about some of the legislative issues that you brought up, some of the things that you mentioned. I want to talk about what's coming up in 2016. Very interesting. I think you'll probably find it very fascinating what's coming down the pike. These are not passed, okay? These are only proposed. Golly, man, you can't see that at all. House Bill 182 by Foyle, House Bill 7 by Price, House Bill 1052 by Henry, and House Bill 328 by Lipinto. House Bill 182, minor in possession. Foyle, we must live in Louisiana. They're going to amend minor in possession. This is a proposal to amend minor in possession. It currently sits at a $100 fine and or 6 months in the parish jail, which means it is probatable. You can put them on probation. You can actually suspend a jail sentence over minor in possession. The proposal in 2016 is $100 fine. They want to get rid of the 6 months in the parish jail and just make it a $100 fine. I really wish I had this when I was at LSU under 21. Regardless if you think it's a good law or not, it does affect probation, because it's a normally probatable offense that is now being proposed by Foyle to just simply say fine only. Be that as it may, don't know if it'll pass, but it is Louisiana, so, you know. House Bill 7, very interesting, as we're talking about expungements. Very interesting. This is, and we've been talking about this in the context of expungements, the cleansing period. When a misdemeanor, you have a 5-year cleansing period, right? Felonies, it's a 10-year cleansing period. But there's a big, giant exception in the context of a felony, and that is unless it's a crime of violence. And crime of violence is enumerated in 14.2. Now, I don't know how familiar you are with 14.2 and crimes of violence, but when you hear that you can have any felony expunged except for a crime of violence, it seems to make sense to you. Well, of course, right? You don't want to expunge murders and rapes, etc. But there are certain crimes, and I'll show you this next slide. These are all of the things that are classified as a crime of violence. It's an incredibly large list that you wouldn't really think about at first glance would be considered a crime of violence. Of course, murder, terrible things we can think of. It doesn't matter how great he is after he commits his murder. We really don't want that expunged. There are certain things, for example, my favorite, and it is proposed in House Bill 7 to... House Bill 7 basically says this: these select few that we're going to identify, we're going to allow these to become expungible. They'll remain crimes of violence, but after 10 years, we'll allow these select few to become expungible, okay? And it's a bill that's being proposed. One of them, I think is a great idea, aggravated criminal damage to property. It's not even to a person. aggravated criminal damage to property. I break a really expensive lawnmower, or get upset at my friend and break his green egg barbecue pit because the value is so high. You got to be kidding me. Crime of violence, and I'm never getting it expunged? I think it makes a lot of sense under House Bill 7 to say, come on, after 10 years we'll think about it. There's another one, though, that he puts in House Bill 7 that I'm not sure will make it. Simple robbery and purse snatching, he might not get those through. But, aggravated criminal damage to property, I understand that. He's also proposing aggravated battery and second-degree battery and illegal use of weapons. You see some cases of an aggravated battery, maybe a bar fight that gets out of hand, and a person stays clean for 10 years after that and never has any issues and now can never remove the violence off their record. I could see the argument there, perhaps. I don't know if he'll be very successful with robbery or purse snatching, but illegal use of weapons might have a shot as well. But the property, that doesn't even deal with a person. It makes no sense to me. It doesn't even deal with stealing from a person. 1052, this directly relates to you. How many of you have ever heard of the Swift and Certain Probation Pilot Program? Swift and Certain. Is there anybody here from Jefferson Parish? 24th. You're in Jefferson?
Yeah, but not 24th. We're First Parish.
Okay. This is being proposed in the 24th JDC as a pilot program, and it's called the Swift and Certain Probation Pilot Program. It is modeled after HOPE. This is Hawaii Opportunity Probation with Enforcement. Hawaii Opportunity Probation with Enforcement. HOPE. It is modeled off of a program in Hawaii where the entire point of it is it recognizes the idea that we are over-incarcerated. It recognizes the need for probation. It recognizes the need to keep people out of the incarcerated system. And so what does this mean? Swift and certain. If you ever deal with any felony, I know this is a misdemeanor section, but I'm sure you've had moments where you've had a probationee that you would like to just kind of immediately send to jail for about a day or two to punish for that clear, blatant violation. They knew what they did was wrong, and a day in jail, kind of a slap on the wrist would make the point. That's what's interesting about this program. This is what it does. It gives a little more leeway to the probation officers to avoid permanent incarceration and say we're going to extend probation all the way to 8 years. It allows an 8-year probation extension on felonies. But it also allows for what they call swift and certain, which means for certain violations, failing a drug test or not showing up to an appointment or whatever the different violations are the probation officers determined to be serious, they can actually swiftly, without filing a probation motion for revocation or a violation, and go into a hearing and asking and begging and trying to impose that 3-month sentence because they've been just delinquent in every regard. And what do? They walk into court after not seeing you for 6 months and they say, I promise, Judge, I'm gonna straighten up. They all do it. Swift and certain says we're going to get the judge out of the way, and the minute you don't report, 2 days, parish jail. Come back and see me. Spend a weekend. Come back and see me. Very interesting. It's a pilot program being proposed in the 24th JDC in Jefferson Parish. They definitely have a lot of situations involving felonies, definitely have, I think, a need to reduce incarceration. So we'll see how that works. Apparently it's been successful in Hawaii, so we'll see what happens with that. And the last one I wanted to mention to you, I think going off of the same, actually all 4 of these bills that I showed you, they all kind of mimic one trend to me, which is they tend to be showing a leniency, if I had to describe it in one way, right? Reducing Foyle's bill, reducing the penalties on the minor in possession. Then you see in the next bill talking about certain crimes of violence now being eligible for expungement. The only one that's really not lenient was the one that I just showed you, the swift and certain probation. But even that is trying to avoid incarceration to place into probation. This kind of sticks in my mind with the idea of making probation more important. And so I think coming down the pike for your organization, you need to be aware that with Louisiana being the #1 state in the country for incarceration, and we are the #1 country in the world for incarceration, which means count yourselves lucky to be in this room because we're the select few that have survived and not going to jail. Because we are the #1 place on the planet for incarcerating folks over Iran and China. We're the #1 state, the #1 nation. So you're going to see a pattern of probation officers becoming more and more important because the intent is going to be to place upon probation more and out of incarceration. And that's what this bill is talking about. It talks about it in the context of a drug court program. If you're in a drug court program, If there is a technical violation in a drug court program, and it goes, I'm not going to go into depths of the bill, but it talks about technical violations being sanctions that are provided within the context of probation that don't lead to revocation. All right. So if you have a technical violation in drug court program, the goal is, again, we're in drug court. The goal is rehabilitation. The goal is to continue to work with them. We're not going to revoke for what they deem technical violations. Now you have to look at the statute to see what is a technical violation. I don't know which one of these four will pass, but I went through doing some research in the 2016 proposal, and they're in session right now to see what affects probation. And these were the ones I thought most interesting that affected you guys. So keep your eye on